All right. We're now, in a very short while, you're going to be asked to make a decision in this case individually. Make your own determination in your verdict on both of these counts of what the appropriate sentence will be for Mr. Colley. First, I want to make sure that, and rightfully so, that we thank you, all of us do, for participating in this very vital function of our society. You've put in so much time in this case, everybody has, and invested certainly your lives, been away from your family and your work, to consider and weigh the evidence that's been before you in what we call the guilt phase, where you were asked to determine at that time, during that period of time, whether or not the state's proven the allegations beyond and to the exclusion of every reasonable doubt. And certainly you've made those findings, and we respect that wholeheartedly. We're here now, obviously, to deal with the sentencing on the homicide counts 1 and 2. And as Mr. Johnson and the judge will very shortly relay to you and lay out for you the law, the jury instructions for you, you're going to go through a process where under the law you have to consider certain things, make certain findings, go through a weighing process, and make your determination in this case. And not only are you going to be given a set of jury instructions on what the law is, and I'm going to highlight some things for you with regard to the jury instructions, but you're going to get a verdict form. And it's going to have a set of questions for you. Not long, yes or no type answers or questions. And we'll show that to you. Another judge will go through that with you. But there'll be a process where you'll see on the verdict form where you'll be allowed to follow the law and render a verdict that will ask you to be, for both counts, life without the possibility of parole. I first want to say, because I think it's extremely important at this point in time, something that just needs to be said. Sometimes it's left unsaid, and I don't want that to happen in this case. We've never argued from the very beginning when Mr. Shoemaker made the opening arguments for the defense in this case, in the guilt phase, that Mr. Colley did not commit the crimes in question. It's not a who done it, it's a how done it. And you've heard evidence in the case, and you've made your decision, and we respect that. We're never going to argue to you, ever, have not, will not, that this is a case where either homicide was justified in any way. This is not a case of self-defense or excusable homicide. Neither Amanda Colley or Lindy Dobbins deserve to die in this case. And Mr. Colley has caused their death, did cause their death, by shooting them. But we're not here to determine whether or not, or make a finding based upon whether or not Amanda or Lindy deserve to die. The law in the state of Florida is if you commit first-degree murder, whether it's premeditated or felony murder, that's against the law. And you know that now you're to consider what the punishment is going to be. So I hope, and I will not in any way say that these are justified. But in the state of Florida, and Mr. Johnson touched upon this, not every first-degree murder case, and we discussed this in jury selection as well too, not every first-degree murder case can the death penalty even be considered. The state has alleged in this case, in what we're going through now, the penalty phase, that they've alleged certain what we call aggravating circumstances, what the law calls as aggravating circumstances. In the state of Florida, and you'll hear this in the instructions, the state is confined, if they want to argue for the death penalty, to those aggravating circumstances that they convince you, prove to you, occurred beyond a reasonable doubt. Again, this is contrary to the guilt phase. This process that you're about to go through is an individual decision that's made by each one of you, each 12 of you. It's going to go back into the jury. But in this case, I ask you, and the judge will instruct you. Again, it's not a question of whether somebody deserved to die. It's only the state is limited to the aggravating circumstances that they allege in this case. So let's talk a little bit about the aggravating circumstances that they've alleged, two in particular. Every case is a little bit different. I've been doing this for a long time. And there's a couple of them I want to talk about. One that applies, one aggravating circumstance that applies to both counts in this case, and one that applies in count one with regard to Amanda. You are allowed to consider, and Mr. Johnson certainly has pointed out on behalf of the state, some of the evidence that you've heard in the guilt phase in this case. And you are allowed to consider that, and it's included in the instructions, when you're considering what the appropriate punishment is. Now, there's also obviously evidence that's been put before you in testimony and exhibits in the penalty phase, and you can consider that as well too. But with regard to the cold, calculated, premeditated, aggravated circumstance, you know that in this particular case, we have a situation where you have two people, James Colley, Jr. and Amanda Colley, who've been married, I believe, for about 7 years. They have two children together, Trey, whose legal name is James Colley III, and the daughter Avery. And you know that there came a time when they came to live in Marabella on South Bellagio, and were raising their kids together in that house. Unfortunately, their relationship started to deteriorate, particularly in July and August of 2015. And their relationship was not going well. They were having some ups and downs in their relationship. Eventually, Amanda Colley sought and obtained an injunction. But their relationship didn't stop there. They kept seeing each other. Mr. Colley, despite the injunction, would go over to the house. You had testimony at two different occasions from Mike Dickens in the guilt phase and Neil Dickens in the penalty phase, where even the days before the homicides occurred, Mr. Colley is with Amanda Colley and the kids playing in the backyard. The Dickens saw this. And they live, 3 houses down from where the Colleys live. So that's important to consider when you're talking about, and there'll be a number of other aspects too for your consideration when cold, calculated, and premeditated. Because this aggravating circumstance requires more than just premeditation. You've already found him guilty of premeditation. Again, under Florida law, you have to have aggravating factors that you can consider in the gravity of the premeditated murder. What I want to talk to you about is a number of pieces of evidence that deal with what's called heightened premeditation. And then there's also this part here dealing with the definition of cold. Because everything doesn't happen, the events in this case, everything in this case doesn't happen in a vacuum. You've heard a number of different things throughout the course of this very tragic events that happened on August the 27th that show you that this was not a long, the homicides did not occur, were not planned over a long period of time, something like you would have maybe in a contract murder case, murder for hire case, where there's long, lengthy plans in advance for what happened. You have a man married to a woman, and their relationship is going back. You have certainly anger throughout what happened here. There's nothing, I'm never going to say anything that tells you that there were not times where anger was not involved in this case, or rage was involved in this case. You have certainly the events that unfold the morning of August the 26th, or the evening of the 26th, and go into the morning hours of August 27th. Remember on that everything happens in an arc. What happened is, Rhonda, Mr. Colley's sister, and her husband Dan are in Rome. Mr. Colley is staying at Rhonda's house because he's left the marital home. Amanda stays on South Bellagio. Mr. Colley's mother and father, JT or James Sr., and Judy Colley stay at the house to help with the kids who are there at the house. They're not with Amanda, they're with Mr. Colley. Mr. Colley puts the kids to bed, and then gets a call from his friend Daryl, goes out to a bar, has drinks, some Crown Oil, several drinks. Unfortunately, has some cocaine, either 1 or 2 lines of cocaine. Again, he's away from the kids, he's with his friends. At this point, he's not with Amanda. Nothing going on between him and Amanda as far as communications go. He's off doing his own thing. And it is what it is. There's some aspects about this case where we have to be very honest with you about it. Mr. Colley is a flawed person. He certainly has issues, as we'll talk about more, with alcohol, in particular, alcohol dependency. It's a chronic alcoholic. His sister says that when he drinks, he doesn't stop drinking. How that plays into the morning of August 27th, we don't know, but certainly the history of Mr. Colley is that he drinks, he doesn't stop drinking. But nevertheless, he's out with his friend, doing his thing, and then when he gets done partying with his friend, then he goes over to Amanda's house at that point. And he wants to check on her, she's been sick, she's not there, goes inside, obviously, finds the sex toys. He's upset about the sex toys, finding them. Goes over and vents to his buddy Mike Dickens 3 houses down, shows Mr. Dickens the toys that he had found, the stuff he had found. And Mike tells him, here, have a beer, go home. So he goes home. Of course, he also breaks the TVs. We find out about that. You had pictures inside the house where he broke the TV. So, but does he stay at the house? to wait for Amanda to come home? Because you know she lives there. I mean, they were there together just a day or two before. Remember, there was a lice incident that occurred a couple of days before all this happened. They've been together. Mr. Colley was not trying to kill his wife or conducting violent acts upon her in the days leading up to all this. They were seeing one another. They had been seeing another. We had text messages that were filed in court as an exhibit that you could look at. Again, and the judge will tell you all this, every bit of evidence that was submitted and put in evidence in the guilt phase, you go back with the juror, we'll go back with the juror, every bit of evidence that's been presented in the penalty phase, which is not as voluminous, that will also go back in the jury for your consideration or review. But we put in text messages where you see 2 days before, or 3 days before this tragic event, on August the 24th, and I'm not going to read all this for you, but there's text messages going back and forth between Mr. Colley and Amanda about the kids, about Mr. Colley talking about whether if she's having an affair. They talk about Trey going to bed, sending pictures of the kids, or do you have a picture of one of the kids? There's discussion. Remember, it's very important too that you also remember that during this period of time in their relationship, there was a divorce that had been filed in this case. They're going through a divorce, which unfortunately happens with hundreds of thousands of couples in the United States. And so there's raw emotion going on here. And this also can be factored into the cold, calculated, premeditated aggravating circumstance. They talk, there's even a mentioning from Mr. Colley about getting full custody and about moving on with their life and just back and forth, conversations with two people whose relationship is falling apart. So all of that you can consider when the big picture about what these folks were going through at the time. And then, again, Mr. Colley doesn't stay at the house. He goes home, he has a couple of Ambien. We'll get into the impairment issues here very shortly, but the chronology of events, you went to court, he entered a plea on a case, but remember too that he had a very favorable outcome on the case. Remember, you heard it on the video, he got probation. He got a fine. He was asked the judge, or I think the judge said for the third time you can pay off your court costs with the bond that you've already had, cash bond you've already posted. So that kind of, back and forth. But then what happens at the end of the plea is, as Mr. Kyle Bertrand told you, is that Mr. Colley actually hugged him, thanked him, was happy, was in a good mood, at that time. So he leaves court, and then that there's more communication between the two of them. You have the text messages and the voicemails. And sure, there's things there that certainly indicate that Mr. Colley is not happy with what's going on. But what also happened is that Mr. Colley is relating to Amanda, let me pay you for the TV. And then, according to some information Mr. Colley brought forward, she mentions about the police being called. And here's where I'll argue, we're not taking this position, but let's assume for a moment that the state's narrative or their argument about what happened next actually happened this way. I'm not taking that position, but let's take their argument for a minute, where they argue that Mr. Colley had gone back to his house and gathered a couple of guns and ammunition and then went over to the house. You heard the voicemail, you heard or saw the text messages. Here is, again, if you take what they have to present it here as their argument, this is not a man that indicates he's planning on killing anyone. Here's a man that is upset about what's going on. And then he goes over to the house. Now you also have information too before you to consider about the fact that Rhonda, when she left for Italy, had her guns in the car. She has a concealed weapons permit, but she had the guns in her car away from Mr. Colley. So anyway, he goes over to the house, right? So then Mr. Colley sees a man and shoots at the back sliding glass door. There's nothing indicating, even at that point, I argue to you, heightened premeditation. There's certainly nothing in the definition of cold, calculated, and premeditated about this being cold in the definition of the product of calm and cool reflection. I'm not saying what he did was right. You've already determined what he did was wrong by the attempted murder charges, by the burglary charges, and certainly the first-degree murder charges. So what he did was wrong, but this is an argument the state has to heighten or aggravate the murder charges in their argument for the death penalty. So there's nowhere, I argue to you, in the scenario of events, even if you accept what they presented in the chronology that they presented in its entirety, that there's any long-term plan, calm, cool reflection. Again, I use my example of a situation where you have a contract killing where, hey, I'm going to pay you so much money, you go out and go find this guy and kill him. Nothing like that ever occurred in this case. According to the state's own testimony, Mr. Colley is upset, he's enraged. And that affects his thinking and in judgment. You've had evidence in this case that Mr. Colley is an impulsive person. Certainly he's an impulsive person, but that doesn't aggravate this into a situation where the death penalty is warranted. So that's that one, and so you don't have the heightened premeditation that this aggravating circumstances requires for you to even consider the death penalty. And that's my argument to you on that. Now, with regard to count one, where you have the stalking, the aggravating stalking injunction, aggravating circumstance. Again, that's an aggravating circumstance that talks about where there's no issue that there wasn't an injunction in this case. But what I want to point out to you and discuss with you, because you have to go through a weighing process, each one of you individually, is what does that really mean in this case? Again, nobody's saying what he did was right. Nobody's saying what he did was lawful. You've made that determination in your verdict when you said he was guilty of aggravated stalking. So I'm not here to justify that part of this case. I'm arguing to you that when you weigh the aggravating circumstances in this case, what does it really mean as it applies to this case? Because again, you have two people that's going through a rocky relationship, that Ms. Colley got an injunction, but she has him over repeatedly the week before. He's at the house days, a day before, 2 days before, a week before all this happened. And I'm certainly not arguing to you about the importance of injunctions. They're very important in our society and our law. But these are two people that have been around each other. So when you're not only considering for yourself and determining for yourself, because although we've gone through the guilt phase part where your decision, your consideration is whether or not the charges have been proven beyond a reasonable doubt, even if you reconsider them, which you must do, the aggravating circumstances, that 5 are for count 1 and 4 for count 2, you must still determine how much those factors mean in your decision about the life without the possibility of parole or death. And so my argument to you is, what does it really mean in terms of the injunction aggravating factor when you have two people that voluntarily are around each other? And where certainly he did wrong, no question about it, on August 27th, but does what he did on the 27th, when you weigh what happened in the days before, aggravate this case, or count one of this case, to the point where the death penalty is justified. And I submit to you, no, that's not the case. As serious as the situation is, as wrong as the situation is that Mr. Colley did to Amanda, does not warrant the death penalty in this case. Now, so that's what I want to bring up as far as the aggravating factors in this particular case. Now I'll go through the verdict with you shortly. The other important part of this process is something I call mercy. It's a very important consideration when you're dealing with the death penalty. We as a culture are a merciful people. Our society is a merciful society. I argue to you that the way the process is designed when considering the death penalty in the state of Florida and the instructions that you now or soon will be getting, that the concept of mercy is built into our system for your consideration in a number of different ways. Again, first of all, not every first-degree murder case you can even consider the death penalty. You have to have at least one aggravating circumstance proven beyond a reasonable doubt. And remember, under the law, the existence of an aggravating circumstance, if proven beyond a reasonable doubt, gets the state in the door to talk about the death penalty. But you'll never, ever be required or compelled to render a decision, a verdict of the death penalty in this case, under the law in the state of Florida, despite the existence of a aggravating factor or other aggravating factors that are listed by the state. That limitation that our society, that our law imposes on the state in even seeking the death penalty, I argue to you, allows for the concept of mercy to take place, because they're limited as to what they can even argue. We value consideration of the human life even when we're to punish the accused for the murder that he committed, murders that he committed. The other part of the concept of mercy is when we talk about how to weigh, and how to consider mitigating circumstances. As Mr. Johnson pointed out to you in his closing, and the jury instructions will tell you here shortly, is aggravating circumstances have to be proven beyond and to the exclusion of every reasonable doubt. The factors that Mr. Johnson's outlined. But that's not the case with mitigating circumstances. Our burden is at 51%. Greater weight of the evidence. More likely than not that the mitigation that we presented is proven to you to your satisfaction by the greater weight of the evidence. So I argue to you that built into that concept is, again, our merciful society where we allow for mitigation, which can be limitless. It doesn't just have to be what's outlined in the jury instruction. It can be anything that you thought about, decided, considered in the guilt phase or the penalty phase. And you'll see that in the instructions as well, too. Mitigation is limitless when you're considering the defendant's life, its background, and the circumstances of this case. So again, I argue too that mercy is built into this by making it easier, if you want to use that term, for the defendant to be able to present mitigation circumstances as opposed to the state's burden beyond the exclusion of every reasonable doubt and limiting on what they can argue for. But then the other part, and I'm going to make sure that this is on the occasion, be in the scroll down. So part of the jury instructions that's going to be read to you, I've highlighted it here. It says, regardless of the results of each juror's individual weighing process, even if you find the sufficient aggravators outweigh the mitigators, this weighing process that we talked about, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Neither compels nor requires you to determine that the defendant should be sentenced to death. I argue to you, because this is the law in the state of Florida, that regardless of what the state has presented to you and convinced you exists beyond a reasonable doubt as far as their limited aggravating factors, and regardless of what weighing you ultimately determined for this, the aggravating factors versus the mitigating circumstances, that when you get through and everything is said and done in this case, the law says to you, regardless of all of that, you never, ever have to return a verdict, a sentence of death in this case. And so I argue to, by placing that and instructing you and having that as part of the law, that relates to the concept we talk about, mercy. That despite everything that Mr. Colley has done, has been shown to have done in this case, when everything is said and done, you never have to impose death in this case. And so the law has made it even harder to impose death if the state sought that. And then the other part is that, and I'll talk about this a little bit more, is when you go into the jury room, how this is going to play out in terms of the process, is your decision on life without the possibility of parole or death is an individual decision. You do not have to be unanimous. You 12 do not have to be unanimous in a decision for life without the possibility of parole. That is an individual one-on-one decision that each of you must determine based on your consideration of the evidence in this case and your best judgment in deciding what is the appropriate sentence in this case. So when you go into the jury room, it is perfectly acceptable for you to consider and weigh the evidence and the circumstances of this case and the mitigation of this case, and you can say for yourself, me, myself, I, based on what I determined to be the case here, based upon my own moral judgment in this case, based on the evidence, I say for myself that life without the possibility of parole is the right call in this case. Me, myself, and I. Unlike the guilt phase, where you know from the instructions of the guilt phase, in order for there to be a lawful verdict, you have to be unanimous. Not so with this phase, with the penalty phase. It's your call individually. And you don't have to agree. Some person may say, no, I think this is what makes it for me. This is why I say life without the possibility of parole is the right call for me. You may have others in your group that say, no, I feel different. That's okay. That's okay. The law allows for that. Mr. Johnson talks with all sincerity about courage in making your decision. I too talk to you about courage in making your decision because again, you are yourself. You're your own cubicle in terms of how you process this case and make your sentence determination. And you must decide for that. And when you make that determination, if you make the determination that life without the possibility of parole is the correct call for you, I ask you to hang on to that. Keep that with you. Certainly discuss your feelings and your decision and your process of why you come up with that call, why that's the right call for you with your fellow jurors in the jury room, but that's your call to keep, and they may disagree with you, and they should have respect for your opinions as well as your opinions and determinations of theirs. It is all about respect. We respect you for the most serious decision that any person would ever have to make sitting on a jury is life or death. And you're in that situation now. So let's talk about the mitigation in this case. And we called some folks for you to testify about, and hopefully we've kind of given you a full flavor of Mr. Colley as a person. He is to a human being in his life, in his career, in his family. I submit to you, should be taken in consideration and will be taken in consideration. We had Gail Dickens, who is Mike's wife, who talked in great detail about what a good neighbor Mr. Colley is. That she has her own children that played with Mr. Colley. She was very forthright and honest in talking about the fact that she has a son that has Down syndrome. And what did she tell you about Mr. Colley plays and has a great deal of patience with her own son, with his Down syndrome, and make sure that he's included in the play activities that all the other kids are doing. You have testimony from Ms. Dickens about how good of a father, Mr. Colley is, and how he interacts with his children, takes them fishing and punting and coaches baseball and football, and does everything that a good father would do. And that you can consider in how Mr. Colley is as a person. And again, we're talking about a human being here. Ms. Dickens talked about J.R., as we all call him, Mr. Colley, helped Sean with his bike and throwing and catching the ball, playing Frisbee with him. And Ms. Dickens and her husband have known the Colleys for a great number of years. Remember, they moved into Marabella before the Colleys did. And of course, both of them, you heard Mr. Dickens and Ms. Dickens talk about seeing Mr. Colley at the marital residence during the week, the days before all this happened. You had Maria Obert Isaac, who's the first cousin of Mr. Colley, would see them at family functions, that Easter and Christmas and holidays and Sunday dinners, and talked about Mr. Colley being a great father, again with the fishing and sports activity, that he is, she described it as having a sweet spirit, that he's always worked since high school. You've had a number of witnesses that talk about Mr. Colley's great work ethic, that he's had a number of jobs, the last 15 of which have been in the financial mortgage industry. But Mr. Colley's a very hard worker and been able to, certainly obtain a house and earn a living. But he has a great work ethic. She knows him through Chase, working in Chase and City, that she lived with Rhonda and Dan and JR for about 6 months. Again, she talks about him being a good father and coaching. She talked a great deal about the fact that Mr. Colley's involved in racing. You had other folks that talked about how close Mr. Colley is to his father, who would go on race car activities with him throughout various locations, and how Mr. Colley worked on the race car and how much he enjoyed doing that with his father and spent time with his father. You had April Ayala that is a second cousin to JR, had moved to Florida in '97, been around his kids, talked about how hands-on he is with his kids. She worked at Citibank, had been retired. She worked there 20 years. Talked about JR working in the mortgage department. Talked about Mr. Colley being involved in several charitable events through work, which again shows another side of Mr. Colley, that he took time to work, as Crystal talked about it, volunteering with Habitat for Humanity. That Mr. Colley, April talked about Mr. Colley being very close to his family, his parents, certainly his sisters, and the coaching activity. We had Frederick Cartwright, who's not related to Mr. Colley. He was a young man who had grown up with Mr. Colley and ultimately went to high school with him. He didn't graduate with Mr. Colley because he went to a private school. But what did Mr. Cartwright tell you about Mr. Colley's good behavior, good background? At school he talked about, remember the one time he talked about when he was being bullied by other kids at the school. They said they were in the 8th grade. And Mr. Colley, JR, stepped in to protect him. There was another instance that Mr. Cartwright talked about where another kid was getting picked on, and JR went and helped that kid out too. At the young age, what are you, 13 or 14 at the time? Mr. Cartwright also talked about the fact that JR is a hard worker. Remember, he talked about that when I think it was his father got sick and needed some help doing the mowing, that without pay, JR stepped in and did mowing. That JR worked and did janitorial work in Daytona for 3 different banks. Worked at Home Depot. So JR's a hard worker, you know. You can take that into consideration. When his father was sick, Mr. Cartwright's father got cancer is when JR stepped in. Talked about Mr. Cartwright again, everybody talks about how good a father Mr. Colley is, and that he's close to his father the most, or his parents equally, I should say. You heard from John Schwinghammer. John is a gentleman that's worked with Mr. Colley at City. That remember they used to work out together. That's how they got to know each other on their lunch breaks. They'd work out together, and when that happened, they developed a friendship where his kids started hanging out with JR's kids, and they started doing things as a family. You have a picture and evidence that's on a disc for your review that was both identified, well actually it's a separate picture that Mr. Schwinghammer identified, and also Crystal identified on the disc, of Mr. Colley being at the beach fishing with the fish in their hands, and all the kids are around him and they're all smiling and they enjoy being around JR. That's another certain aspect of JR. You had Mr. Schwinghammer testified again about Mr. Colley doing charitable work, working there, volunteer work there at the workplace. That JR was, again, a coach for flag football. You had Jason Deloach, again, a friend, not a relative, who came forward on his own, took the witness stand, and talked about how good an employee Mr. Colley was, that he was a good producer financially, that he was a mentor to other people in the workplace, that he was a motivated person, very reliable, very trustworthy, did customer service in ways that other people at the office couldn't do. He stepped up and was a great employee. And witnessed him being a father. Again, was a good father. He talked about that the kids would light up every time, or he would light up every time he was with his kids. that he would help other new employees in their training. Again, this is a human being we're talking about when you're considering whether or not to put him to death or give him life without the possibility of parole. You had John Wright, who is Crystal's husband, who, you know, Crystal and John have had their times being separated, but remember that John, for a period of time, lived with Amanda and JR. That John and Crystal have their own daughter, Savannah, that JR would play with and adored, and likewise. John, too, testified about what a great father JR is with the kids, and kids in the neighborhood adored being around Mr. Colley. He was a good influence on them as well. That he was great with animals, used to play with the dogs. Had several, we had other people talk about how good he is with animals. Crystal talked about that. And that he was a good uncle to Savannah. You had then, just yesterday, trust me, my days are kind of blurring together. We've been here a long time together. Yesterday you had Crystal Colley, his sister, who told you some honest truths about Mr. Colley as a person. Both some good stuff and then some flawed stuff. Crystal was the one that really pointedly told you Mr. Colley is an alcoholic. She was the one that told you that when he drinks, he can't stop drinking. That he's a binge drinker. That she and others have told Mr. Colley, hey, you need to get help. You know, this is a problem. Unfortunately, Mr. Colley never did get the help. And obviously didn't initiate that himself, but he's an alcoholic, chronic alcoholic. And you had additional backup with Dr. Kuroga talked about that when she testified. But Crystal, too, knows that Mr. Colley and she and her sister Rhonda, the three of them, are very close together. And she talked about the history of Mr. Colley, you know, growing up, that he was born in Illinois in Elgin and then moved as he was a child to Orange Park and went to school in Orange Park. And then when he got older, when JR got older, moved to Volusia County, went to high school there, graduated from Seabreeze in 1999. And then she too talked about his employment history and how good of a worker is, and that she also too works in the finance industry. Talks about how good of a father he is as well, and gave you a lot of information, you know, about that. She, you know, talked about him, you know, working for humanity, Habitat for Humanity, and doing the boat racing stuff for charity, you know, etc. But she also told you, you know, about the alcohol use. She talked about cocaine use. And that's an example of that he's not a perfect person. And unfortunately, in our society, in our country, we have a lot of folks that are alcoholics. And it would have been great if Mr. Colley had gotten treatment early on, but it didn't happen. She also told you about a couple of times, well, she knew about his back history and pain medication that he had, but she also told you about the domestic violence that her mom committed when he was a child. Remember, Crystal's older than JR. That, you know, Judy took a baseball bat to his father in their presence when she apparently caught him having an affair on him. That a week later they witnessed Mrs. Colley, Judy Colley, their mother, taking a knife to their father. Now certainly there was never an arrest in this case on either instance. Crystal told you they reconciled after that. They're still married today. Unfortunately, Mr. Colley, the father, is in very, very bad health. And there's been some testimony about that. Now, the state certainly talked to you about the fact that when cross-examined, she was confronted, Crystal was, about the fact that she denied domestic violence, that she had witnessed that when she was being cross-examined. Keep in mind the circumstances of how this information is unfolding, because, ladies and gentlemen, I hate to state the obvious, but this case has been, you've had media coverage in this case. You've had reporters in here. This is in live, in color, in front of a ton of people, talking about what she experienced and saw in court. She said it was not easy. And she was embarrassed that other people, knew about it. So it's extremely difficult in circumstances to talk about this sort of stuff. Nobody does. But despite all of that, the parents reconciled, and then, as you already know, the family unit is very close together. So these circumstances that I've outlined for you, the judge will read to you in here very shortly the mitigating circumstances. And again, these only have to be proven by the greater weight of the evidence. Now, we also had testimony, expert testimony from Michelle Kuroga, who is a neuropsychologist. And what she was testifying about, did testify about, is what we talked about in number 11, mitigating circumstances. Mr. Colley has a history of drug and chronic alcohol abuse. Certainly that was part of her evaluation, and that she determined and gave the opinion that Mr. Colley was suffered from alcohol dependence. And also to that 19 and 20, that Mr. Colley was taking pain, antidepressant, and sleep disorder medication at the time of the homicides, and certainly number 20, which has not been refuted, that Mr. Colley has previously been diagnosed with depression. You've got, even on that score, you've got testimony from all the doctors, actually, that Mr. Colley, in August of 2015, was taking depressive medication. The first, Wellbutrin, and then that was discontinued, and then Cymbalta was prescribed for him on August the 10th of 2015. So Mr. Colley suffered from depression. Then he suffers certainly depression, while the big diagnosis was depression since he's been in jail. Facing these charges. And that's a mental health condition that certainly you can take in consideration with regard to Mr. Colley. Now, I call her Michelle, Dr. Kuroga also talked about the fact that, let me get you the number on the mitigation on this list, that he was number 23. James Terry Colley Jr. was adjusted well to his incarceration since being arrested in this case. Dr. Kuroga testified that since Mr. Colley's been in jail, that he's done well in the jail. Remember, she talked about that in terms of him taking care of himself. She told you that he's taken become a certified paralegal, taking a paralegal course while in jail. So you have that information for you. And why is that part important? Why does 23 have significance in this case? Because when we're talking about the appropriate sentence in this case, the appropriate sentence in this case is life without the possibility of parole. Here is a man, if that sentence is imposed in this case, is going to spend the rest of his life in prison. He's demonstrated just in the 3 years that he's been here, and certainly nobody's making light of the fact that he's incarcerated, and deservedly so. He killed 2 people. He's incarcerated. But he's going to be able to do okay in prison because he's done okay in the jail here. Not saying that's a great thing, nobody is, but you can take his behavior and how he's adjusted to jail when you consider the appropriate sentence of life without the possibility of parole. Now, certainly there's been testimony about impairment. That's one of the list on the list of mitigating circumstances. And again, this is a list that's actually these are the ones that are listed, but you can consider anything else in this case, and that's number 24, which is what we would call the catch-all mitigator, which is existence of anything, any other factors regarding Mr. Colley's character, background in life, or circumstances of the offense that would mitigate against the imposition of the death penalty. That could be things I haven't brought up that are not on this list, that nobody's talked about, but it's on your mind. You, hey, this, I caught this. Maybe the fact that he did well in high school, he had good grades, he was on the honor roll. Maybe that's something you want to think about. Maybe there's something else about what's been presented to you that's not on this list, but it's important to you. And there may be things, and this is in the instructions too, there may be things that one of you thinks about, hey, this is really important for me. This is why I want to do life in prison. I think that's appropriate. And somebody else may say, well, you know, this other thing is really important to me too. That's okay. You don't all have to agree on the same mitigators. And it could be something else that we haven't talked about. Lawyers, being lawyers, we kind of get a little narrowly focused sometimes on what we think is important, but that doesn't mean that that's not important to you. And so keep that in mind. But let's talk about a couple of the factors that are on that list, which we seem like we spend a lot of time for. We had expert testimony that sometimes takes a while to get through and digest and all that, which is the impairment. And again, mitigating circumstances, think of the scales that are right before the judge. Just a tip, just a 51%. There's been no dispute in the evidence that in August of 2015, Mr. Colley wasn't prescribing anything. And that previously, before August the 10th, he was on Wellbutrin, and then he had the change of medication to Cymbalta, another antidepressant. Dr. Buffington talked to you about how it takes a while for medication to really take its full effect. It takes a few weeks for that to happen, and then through doctor's orders, for whatever reason, Mr. Colley has switched to another medication. All that has an effect on the body. But Dr. Buffington, the pharmacologist, talks about the neurotransmitters and how that can affect the mind. But on the morning of this tragic set of events, Mr. Colley takes the Ambien. You had Dr. Mills and Dr. Buffington, Dr. Mills being the psychiatrist, talk about how this parasomnia can affect from Ambien, which is an known adverse side effect, how people can do intricate things, how people can even sleep drive and do other types of activities and then not remember what they were doing. I think this was even talked about by a couple of jurors that had that experience during jury selection. But we have a situation here where Mr. Colley takes medication in the stupidest way. I mean, let's be honest. You got to get up in a couple hours, and then you're going to take the Ambien. But what happened before that? Take that in consideration. He's out partying with his friend Daryl. They were out until 2 or 3 o'clock in the morning. Gets home about 5. And he's had some cocaine that he's done before. Now he's wired, he's up, he's got to get some sleep, he's got court. It's important, obviously, to attend court. So he's got to get something to take him down. And then he's woken up after a couple of 2-3 hours by his dad, and the Ambien hasn't even really peaked at that point in time. And we've had testimony, expert testimony from Dr. Mills and Dr. Buffington, how they even explained, he can text, he can do things even when he's being impaired by the Ambien. Wasn't taking any other, took his other pain medication, according to other information that you had that morning, and goes to court, and then the other events unfold, as you know now, and has been talked about extensively. So you had two experts, one's a psychiatrist and one is an experienced pharmacologist. The pharmacologist talked to you extensively about adverse side effects of Ambien that is well documented, that is known through literature that all experts have in the field. And you can consider and weigh their testimony and their expertise. And I ask you to consider that in whether or not Mr. Colley was either impaired or substantially impaired at the time of the homicides. And that's for your consideration. We know certainly he was upset, he was enraged, but movements can also be affected by Ambien. All right, so let's put a couple of things up for you. You know now that, and we've talked about this, that your decision is an individual decision, and that you have every right to hang on to your decision once you've made that decision in this case. We ask you to do that when you come to the conclusion that life without the possibility of parole is the correct decision, the correct sentence in this case. What does that, what are we really talking about here? Again, we talked about this, you do not have to be unanimous in your decision about life without the possibility of parole being the right sentence in this case. We've talked about mercy, that's inherent. This is, I pulled that out separately to remind you that you do not have to, no jury ever has to determine or is required to render a death sentence in this case. Sometimes, and this was discussed a little bit in jury selection, and I wanted to make sure we're all on the same page about it. We're talking about your feeling, when you talked about your feelings about the death penalty, and there was discussion about following the law, and I tried to make sure in jury selection that you understood that life without the possibility of parole is a legal sentence. It is one of the options that is available to you at this time. The law says that that's an appropriate sentence. And hopefully all of you understand now that if you determine for yourself that life without the possibility of parole is your decision, you should know and always know that that's a legal sentence. And that is one of your options in this case. Let's really talk about and get into what we're talking about here. You know, after everything is said and done, we're really not talking about how Mr. Colley will live after today. We're really talking about under what circumstances Mr. Colley will die. And I know that's a weighty decision for you to talk about. And certainly, I don't know what you're going to talk about in the jury room. Obviously, we don't go back there with you. But some of you may be thinking along the lines of the mitigation and what we presented to you, and there's a great deal of that. I argue, too, that the weight of the aggravating circumstances, either by themselves individually or in total, outweigh the aggravation in this case if you go through that actual weighing process. But if you impose a life without the possibility of parole sentence for these counts, he will leave prison in a plain box. That's what that sentence guarantees. He's going to die in prison. That's what we're talking about. And that's a lawful sentence. So I want to talk to you about punishment, because that may be something that may be on your mind when you go into the jury room, as you're considering that lawfulness and appropriateness of that sentence. You know, It's noon today. If Mr. Colley were in prison at this very moment, tomorrow at noon is going to look the same for him as it will for every other noon, for every day, every week, every month that he is on this earth. To the point that someday, for whatever reason, however it comes about, God takes him from this earth as he's serving his life sentence, because he'll never be able to get out of prison on either account when that's the sentence. That's what we're talking about for Mr. Colley, for what he's done in this case. And that is a legal sentence, and that's a sentence that you can impose. So if you're thinking about punishment, this is the punishment that Mr. Colley, under the law, deserves. If that is the thing that is most on your mind, is the punishment that he deserves. If that's on your mind, that's the sentence for you. Life without parole. He dies in prison. When, how, every day for the rest of his life is going to look the same in prison. Every day for the rest of his life, he's going to have to deal with what he's done in this case to two people that he killed. And what happened leading up to that? Those tragic, serious consequences for what he's done. Life without parole does that in this case, ladies and gentlemen. And that's a decision that he will have to live with the rest of his life, how long that is, in prison. And that's the appropriate sentence, I argue to you in this case. That's the right thing to do. And I ask each and every one of you to think about this case individually and say, hey, this is the call for me. I need as many of you as we can. If it's unanimous that life without parole is the right call for you, great. 10, 9, 8, doesn't matter to us. However many possibly that you decide. But know whether it's a merciful decision or a punishment decision, life without parole is what does it in this case for both counts. Now, how you do that is on the verdict form. And the judge is going to go over this with you, so I'm not going to go over it in great detail. And there's going to be two for you because we're dealing with two counts. But built into the law and the process, you're going to go and make some determinations about the aggravating circumstances and whether or not any of them have been established, and then you'll make a finding as to mitigating circumstances, and certainly there have been a plethora of mitigation presented in this case for you to check yes. And then D, you're talking about a weighing process, whether or not the aggravating circumstances outweigh the mitigation circumstances. I argue to you no. But there's several off-ramps that are in this decision. Even if you were to even go to the first one, Section A, if you do not think there were any aggravating circumstances that have been proven beyond reasonable doubt, then you stop there and your decision in life that Mr. Colley will be sentenced to life without the possibility of parole. But then you go on from there and make other decisions, and when you go through the weighing process, but then you come to the very end, after everything is said and done, in Section E. And after you've made your weighing process for yourself, again, individually, you're asked to decide whether or not, or asked to determine whether you unanimously found that he should be sentenced to death. And then it's a yes or no, and under that you're told that if your vote to death is less than unanimous, the court will impose life without the possibility of parole. And here is I submit to you your final out on that from a legal perspective, from the legal instructions. It's going back to this instruction that tells you, and you get the E, that regardless of the results of your individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. That, ladies and gentlemen, is what we're asking you to do in this case. 1, 2, however many of you individually decide that's the right call, make that call for yourself, hang on to that call for yourself, go into the jury room and tell the other jurors why you feel that way, but hang on to your life decision. And render a sentence in this case that's both lawful and punishment that Mr. Colley deserves in this case under the law. A life without the possibility of parole. Thank you.